Hello, my name is Parker Dishnowski, and today I'm going to be speaking on the concept of neo-feudalism and how this applies to gaming consoles. Neo-feudalism is the concept that a person does not own property, but rather his property is owned by others, and may be taken away from him at any moment. While this may seem like a sci-fi concept that could never come true, this has in more recent years become a thriving business model, especially in the field of gaming consoles. This has come to be due to the Supreme Court rulings that allow physical property to be considered intellectual property. These rulings are significant, as intellectual property is only ever considered to be leased to the consumer, not ever truly owned by him. This definition certainly does not seem fitting, as intellectual property has something that physical property does not: a lack of physical existence. So how is physical property now, in some cases, legally considered intellectual property? Well, it turns out that the law does not recognize the physical property to be the object protected under law, but the code located inside the physical property to be protected as it is intellectual property. This classification oftentimes does not tend to change anything for those who use the products normally every day, but for those who explore the full potential of their products and modify them, this can cause significant issues, as such actions can be a form of copyright infringement. Copyright infringement is not only a guideline but rather a law which is capable of punishing those who do not obey it. The law protecting intellectual property is located in the U.S. Title 17, which can be found on their website, U.S. Code Title 17 Copyrights, which is a government website that outlines rules of engagement concerning copyright. Perhaps one of the most important rules concerning copyright that is outlined in Title 17 is the right of the legal owner of the intellectual property, which is not the consumer, to redact the property leased to the consumer. While copyright on its own is not a bad thing and has many positive uses, such as the protection of intellectual property against people who unrightfully sell the content without compensating the owner, it can also be misused in such a way that turns the law from protecting the owner to oppressing the consumer. Such laws being exploited for the gain of big business can take place in many different ways. One good example of how laws are exploited for their gain is through the vague language that is seen inside of the contracts between the gaming companies and consumers. While typically a vague contract is one that can typically be dismissed on the grounds that it can easily be misinterpreted, as noted by the article What Are Vague Contracts? Legally speaking, interpretation on behalf of the body that is hearing the case is bound to change. So what do I mean by that? To put it simply, the judge may or may not throw out the case, and the judge's mind is bound to change with time and the current state of the nation legally and physically. While this may seem like an obvious thing to point out, this also means that time can change a vague contract's entire meaning. A good example of how this is currently happening can be seen by Nintendo. Nintendo's contract is extremely vague and claims to hold the power to ban people from their Switch 2 if so they infringe on the user agreement through, quote, publish, copy, modify, reverse engineer, lease, rent, decompile, disassemble, distribute, offer for sale, or create derivative works of any portion of the software, bypass, modify, decrypt, default, tamper with, or otherwise circumvent any of the functions of protections of the console or the software, including through the use of any hardware or software that would cause the console or the software to operate with any unauthorized, illegal, or pirated software or hardware. Reinstall any prior version of the software on the console, or otherwise obtain or install any version of the software other than through distribution methods provided by Nintendo. Install or use any software which Nintendo identifies as unauthorized copy, or from which one or more unauthorized copies have been made, or exploit the software in any manner other than to use it with the console in accordance with its documentation and intended use. This whole user agreement, as taken directly from the official Nintendo website, quote, Nintendo Switch 2 user agreement / Nintendo support. This vague contract is not merely one that holds the ability to kick you from online services, but one that aims to remotely disable the physical hardware of the Switch 2 and eliminate all games that you currently own from the Switch 2 by erasing them, as they are all digital now and no physical discs exist anymore for the Nintendo Switch 2. This is extremely concerning, given that most people, like my friend, own thousands of dollars worth of property that could be disabled at any time over vague contract that is changing continuously as Nintendo continues to gain a bigger legal presence, allowing for them to sway courts more to their sides. I'm currently not against a user agreement, and in many cases support it, but Nintendo has undoubtedly taken this agreement way too far. In a world where gaming companies make their own laws through agreements, I believe that they have a responsibility to the consumer to make their contracts as clear as possible. And I also believe that legally all contracts that are in the gray need to be avoided. While this issue is one that needs more light shed on it in our modern day, there are unfortunately many more ways in which laws are exploited for the good of big business. One way this happens is through the classification of physical property as intellectual property. I know I already talked a little bit about this in the beginning of the video, but I did not bring up the laws surrounding physical property being protected under copyright law. While the premise of why physical property is considered intellectual property is due to the fact that it has code inside of it, the courts have more recently given the name intellectual property to physical items. This was first seen about 25 years ago, when the Supreme Court ruled that gaming consoles are considered intellectual property and defined gaming consoles as devices that can be played by loading a disc into a console, which is then connected to a television. This was mentioned in the article, quote, legally speaking, what even is a gaming console? / law sci forum. Well, this was the first case of a physical piece of property being considered intellectual property. This classification did not only stay with gaming consoles, but has begun to infect many different assets of society, such as farming. As mentioned by the article, quote, the right to repair, why farmers are fighting for equipment access. The definition of intellectual property has come for tractors as well. And we see that farmers are outraged by this definition, as it makes it so that they can no longer repair their tractors, but instead must go to expensive mechanics provided to the farmers from the parent company of the tractor. Not only is this expensive, but there are multiple reports of tractors not being fixed for months due to them being on a wait list. This is a very serious issue, but I want to refocus on gaming consoles. I simply brought up the issue of tractors being considered intellectual property to showcase how the classification of one device as intellectual property oftentimes does not stick to that device alone. Not only has the classification of intellectual property jumped to other property, but it has in more recent times become a very vague and rather unregulated. We see that gaming consoles are specifically designed to run video games, and because their existence is built around running code, which is intellectual property, it is given the status of being intellectual property itself. This at the surface seems to make sense, but in recent times, gaming consoles can also stream television shows, grant you internet access, and allow you to voice call your friends through it. So how does this differ from a phone or computer, other than the main way of interacting with it is through controllers? The answer is that it is not different, and it would be easy for potentially all electronic devices to be considered intellectual property, ranging from your gaming rig to a calculator. I don't know about those watching my video, but I sure hope that my calculator in the future does not have a copyright infringement agreement attached to it. Imagine downloading Doom on your calculator and having your calculator destroy itself. It sounds ridiculous, but that is the direction we're heading with the overwhelming speed at which ordinary items are being considered intellectual property. While consoles being considered intellectual property is understandable in some cases, there should be rights for the consumer and agreements should not be upheld as laws. Nintendo, as seen with its Switch 2, does not allow for any modifications of its game, although it is legal to modify games according to the article, quote, "Is modding a console illegal?" /expert beacon. I find it to be reasonable that user agreements should only account for what must be abided by to keep access to non-fundamental services such as online play. For all other aspects of the gaming console, US law should define what is and is not allowed to be done by individuals who own gaming consoles. In the case that a person is in violation of the US law, it should be up to the gaming company to determine what should happen to that person's gaming console, or if there should be physical reparations for breaking the law. Overall, these issues discuss between the issue of vague language surrounding agreements and the ability of companies to have legal power over you and your property by making you sign an agreement over issues that currently plague our society. And I encourage everyone who has seen this video to be mindful of the laws that are being used to benefit big business at the cost of harming the consumers, aka me and you. Thanks for watching, and please share this video with someone who you think would benefit from watching this. God bless. Parker out.